The Zarda case was initially filed by a skydiving instructor who alleged that he was terminated after telling a client that he was gay. He filed a charge with the EEOC alleging that his discharge was the product of unlawful gender stereotyping under Title VII of the Civil Rights Act, as well as sexual orientation discrimination in violation of New York law. The district court considered the issue and granted summary judgment in favor of his employer on the grounds that gender stereotyping is not covered by Title VII with respect to sexual orientation. And the Second Circuit, constrained by prior precedent, affirmed that decision before revisiting the decision en banc. The majority opinion began by looking at whether sex is a motivating factor in the alleged unlawful practice. And in this case, looking at sexual orientation discrimination, the court concluded that sex is a factor and inextricably linked to sexual orientation, and therefore sexual orientation acts as a proxy for sex. And in holding in favor of Zarda, the court adopted three theories that had previously been advanced by the EEOC. The first is that, but for the individual's sexual orientation, which again was acting as a proxy for sex, the plaintiff had been discriminated against. And the court also notably applied what's called this comparative test by comparing not a lesbian woman to a gay man, for instance, but a lesbian woman to a heterosexual male, and found that but for the fact that a lesbian woman is a female, she was treated differently because of her sex and sexual orientation. Secondly, the court relied upon the Supreme Court decision in Price Waterhouse to conclude that sexual orientation discrimination constitutes unlawful gender stereotyping. The court also looked to the Supreme Court's decision in Loving versus Virginia to conclude that sexual orientation discrimination is a form of unlawful associational discrimination. The Second Circuit now joins the Seventh Circuit in finding that Title VII does protect against sexual orientation discrimination, and deepens the circuit split with the 11th Circuit, which went the other way last year. Because of that circuit split, we would expect that this issue to be taken up by the Supreme Court, and the question is just when that will happen. In the meantime, we would expect that other circuits will consider these issues, and especially because the Second Circuit decision was so broad and considered so many issues, there's a good chance that at least one of those theories will be adopted by other circuits around the country. The Second Circuit comprises New York, Connecticut, and Vermont, all of which already have state and local statutes that expressly prohibit sexual orientation discrimination. So employers in the Second Circuit already should have policies and practices in place to prohibit such discrimination. And if they don't, they should put them in place now. But even employers who operate in whole or in part in either the Second or Seventh Circuit are encouraged to adopt a uniform policy to make sure that all their employees are treated fairly and equally, and to prevent further legal challenges in the future.